The following is a paid presentation by Siniard Law Injury Attorneys, paid for by Siniard Law Injury Attorneys. The Siniard Law Show, answering your legal questions, featuring attorneys Tommy Siniard, Bart Siniard, and your host, Aaron Dacey. This is the Siniard Law Show.
Good evening and welcome to the Siniard Law Show, where we invite your legal questions and educate you on various areas of the law. Tonight we're talking about injuries, everything from car accidents to slipping and falling, and we'll break down common issues when it comes to injury cases in just a moment. Siniard Law is a father-son personal injury firm right here in the Tennessee Valley, focused on giving back to the community through legal education. Siniard Law has again received a recognition as a Tier 1 personal injury litigation firm by Best Lawyers in America. Bart Siniard is on the list of Best Lawyers in America 3 years running, and Tommy Siniard, his father, has more than 3 decades of recognition by Best Lawyers in America. Tonight, as I mentioned, we're discussing injuries, and this is a specialty of the Siniard Law Firm. Bart Siniard and Harrison Lane are tackling this one, or should I say many, because there are a lot of issues that can happen when it comes to injuries.
Yeah, it really can run a wide gamut of issues from, we handle car accident cases, trucking accident cases, workers' compensation for people who are hurt on the job, medical malpractice, something goes wrong in a hospital or a nursing home. We have a whole category just called miscellaneous, like crazy things can happen, accidental shootings, stairs collapse, elevator breaks. There's all kind of crazy things that can happen out there. Nobody likes to think about it because you never think that's going to happen to you. But unfortunately, doing what we do for a living, it does. We see bad things that happen, and that's why personal injury lawyers are here. Happy to have Harrison Lane with us here tonight. He's been with us more than 3 years now, is doing a great job.
Yeah, I was happened to notice that the Best Lawyers in America 3-year thing is kind of running around the time that I started with y'all. So
he gets credit.
Very good. Yeah, You're next in line then, Harrison.
I'm happy to be here. I'm excited.
Harrison's doing a great job and recently settled one for $250,000. Mm-hmm. He's been doing a good job, having a lot of big outcomes. So we're really proud of him, and he knows just as much stuff about this as I do, and he's going to help us answer these questions.
Very good. Well, if you have questions on this topic or any other legal topic, just email us at questions@siniardlaw.com or call us at 844-7000-LAW, and your question may be featured. Now to our legal tip of the week: common pitfalls of handling your own car accident injury claim. So is this a good idea?
It can be, depending on a lot of things. We have a lot of clients, because we're not on billboards, we're not, on a bunch of TV commercials. We end up getting a lot of clients who did try to do it on their own, unsuccessfully, and then ended up on the internet Googling, trying to read about it, and that's how they find us, because we have a lot of information about the process on our website. But there are a lot of ways to mess it up, handling a car accident personal injury case. I tell people that if insurance companies treated people fairly, that we wouldn't have a job. I mean, it should be fairly straightforward. Some of it's common sense, some of it's not, but there's a lot of different ways you can screw up, and recorded statements, using social media wrong. I mean, there's a lot of different things. Tell them, what are the most common mistakes you see people making when they're trying to handle their own case?
Well, there's a lot, right? I mean, you mentioned a recorded statement. The insurance company calls you, and they basically just say, well, tell us what happened. And you start talking and telling them exactly what happened. The problem is you may say, I don't know how the wreck happened. I'm uncertain what happened. I may have been speeding, but I wasn't speeding by that much, right? All of those things are going to be used against you. So that's a big pitfall that we see. And another one, I know Bart and I have talked about it before, is the issue when, what happens if you're so injured you handle it yourself, but the the liability insurance company or the person that hit you, their insurance company tenders whatever their policy limits are, and you go to make an underinsured motorist claim. Bart, do you want to talk on that?
There's a lot of moving parts, because particularly if you're badly hurt, if you just go to the hospital and get checked out, you can probably figure it out on your own. But if there's a lot of medical treatment, a lot of medical bills, the chances are decent that the at-fault driver either has no insurance or has the state minimum that's required, which is only $25,000. And then there becomes a lot more moving parts if that's the case, and you've had to have a bunch of medical treatment, because then you have to look at other sources of compensation and how you go about that. There's ways that you can mess up the $25,000 that may have already been offered or tendered, as we say in the legal industry. You have to look at uninsured motorist coverage with your own insurance company. You have to look at, was the at-fault driver potentially on the job or door dashing or Ubering or running an errand for somebody else who could be held financially liable. The other pitfall I see a lot, and I've tried to undo this for some people who spent months and months and months trying to handle their own case, is the issue of what's called subrogation. If you have health insurance, including Medicaid or Medicare, and they pay for medical treatment after you've been in a car accident, they are entitled to be reimbursed out of your settlement. And nobody tells you this a lot of times.
You figure that's a public program.
Well, I mean, you would think.
Taxpayer money
Medicare,
paid.
Yeah, but I mean, Medicare, Medicaid, Blue Cross Blue Shield of Alabama, whoever, they want their money back, and they're legally entitled to. And a lot of people don't realize that.
What's the word for that?
Subrogation. Subrogation. It's just a fancy word that means they have a right to get reimbursed.
Well, and the big issue becomes is that people end up cashing that check from an insurance company without ever getting a letter from their health insurance. And all of a sudden, they have no money left from their settlement. Now they owe Blue Cross Blue Shield $5,000. Where are you going to come up with that?
Yeah. I mean, I tried to help a guy. It's been a couple of years now, but he got $100,000, which was all of the car insurance money there was available in his case. The at-fault driver had $50,000 in liability. He had $50,000 in underinsured motorist coverage. So he got $100,000. And it really wasn't enough for how bad hurt he was, but he didn't want to hire a lawyer. He figured out he got all the money. And then like 3 months after he got his settlement, he gets a letter from Blue Cross Blue Shield saying they're entitled to $90-something thousand. And they are. If he had had a lawyer, you could have headed that off. There's ways lawyers can get that subrogation amount reduced and negotiated. There's a few different legal principles we can use. But one of those is completely eliminated if you don't have a lawyer. It's called the common fund doctrine. So a lot of people will be like, yeah, I got all this money, and then find out weeks or months later, wait, Medicare is coming after me, or Blue Cross is coming after me.
I've never heard that. That is, boy, you really do need a professional. The great thing is that you don't have to do it alone. Somebody can come and talk to you guys, and they don't have to pay anything, and just find out whether or not this is going to be a good idea to handle it on their own or not.
Well, absolutely. And, we charge no fee for anybody coming to meet with us, right? And we don't charge a fee if we take the case. And the only way that we're paid is if, we're able to recover something on somebody's behalf. And the thing I think that we see a lot of people come in just to get information. And we're perfectly fine with that. If you just want some information about what to do, what are your options, where do you go, we provide that. This is what we do. We help people who have been injured. It's not always, I'm only going to help you if I'm going to make money. We're here to sort of help the public, like with the show. So, we always encourage people, reach out to us. Worst case scenario, we give you the tools to handle it on your own, but more than happy to help if needed.
All right, well, let's get to some of our viewer questions. We have a voicemail from Wanda.
I was involved in a car accident recently. I ended up having to go to the hospital for some minor injuries, but the other driver doesn't have insurance. I'm just wondering how I can go about getting my car fixed and any medical bills I have paid.
Aaron, this is one of the most common questions we get when we have somebody call our office. And I've said it before, I'll say it again. There are a lot of people driving around in Alabama, and a lot of states in general, but Alabama's number 7, I think, for the highest amount of uninsured drivers. 19.6% of cars on the roadway, for whatever reason, they don't have car insurance. They got a month's worth of insurance and got the proof of insurance card and got their tag renewed and then didn't pay for the next month. And there's no way for law enforcement, to keep track of all that on the front end. So we see it a lot. About 1 out of 5 drivers out there don't have car insurance. And so this viewer has to hope she has what's called uninsured motorist coverage. Alabama, it's mandatory that your insurance company offer you uninsured motorist coverage. We frequently call it coverage, the acronym. But if you have that, it steps into the shoes of the wrongdoer. You can go after your own uninsured motorist coverage with your own car insurance company, and that's not supposed to make your rates go up. And what's also great in Alabama is you can stack up to 3 vehicles worth of that uninsured motorist coverage. So for example, you own 3 vehicles and you have just $25,000 in uninsured motorist coverage on each vehicle. Well, if you're in a wreck and you're hurt by somebody who doesn't have car insurance, you have $75,000 available to go after with your own insurance company. She may also want to check in and see if she has what's called MedPay. Mm-hmm. Talk about that.
Yeah, so medical payments coverage, or MedPay as it's commonly referred to, is typically going to be something underneath your policy that it's kind of is what it says it is. It's for medical payments, right? You've incurred medical bills, but if the other or at-fault person has no insurance coverage, you may be getting these bills in the mail and they could stack up pretty quickly to a point where, you're starting to drown in these bills and the debt. And so what you want to look for is your medical payments coverage. And that is just an allotted amount of money that you choose under your policy that is meant to help cover those bills, those expenses as they come in following a wreck. So you really want to make sure that you're looking within your policy to do that. And another big thing that we see is people not double checking the validity of their own policy. Mm-hmm. I mean, it's just because you think you have State Farm or you think you have insurance coverage doesn't always mean that you do. So the important thing is to reach out to either your agent or whomever it is that you're purchasing your insurance from and making sure, hey, what is my policy? Is it current? Has it lapsed? Because a lot of times people put it on auto draft. They never check it again. Mm-hmm. And then they end up in a scenario where they got a new card and didn't update it, or they missed the email that says, we had to redo our system. So it's just one of those things, just for your own well-being, you want to stay on top of and make sure that you have that insurance coverage.
Let's get to this email question here from Hillary. She said, I was at a friend's apartment complex going up the stairs when one of the steps collapsed. I cannot get the apartment manager to call me back. I broke my ankle. What are my options?
So that's a premises liability case. And what wasn't clear from the question is like where this stairwell is. If it's in a common area, in my mind, what the caller's describing is, like a common staircase that goes up to a bunch of different apartments. If that's the case, then there's very likely a claim could be successfully made against the apartment owner and or the apartment manager. They have a responsibility to inspect for hazardous conditions, decaying steps, all of those things. And if it's like a stairwell inside somebody's apartment, well, that you could look at potentially, is the apartment renter liable for not telling somebody if they knew it was starting to give way? So a little bit of it depends on where the stairway is and whose responsibility it was. But I've had a case just like that where it was rotting steps and you couldn't really tell because they had painted over it to try to make it look nice. But then we were looking under it and the wood's just completely rotted. It was an exterior staircase that just collapsed.
Wow. All right. Well, thank you both, and stay with us because the Siniard Law Show is returning in a moment with more tips to protect yourself when it comes to injuries, and we'll tell you how to sign up for the Siniard Law free newsletter.
Harrison Brothers brings together the best of North Alabama. Our curated selection of local art, fine crafts, and gourmet food are great gifts for everyone on your shopping list. We carry books by local authors, and our toys pique a child's imagination. At Harrison Brothers, your purchases support artists and artisans right here in the Tennessee Valley. Located on Huntsville's Courthouse Square since 1897, Harrison Brothers is more than a store. It's a tradition.
I got sandwiched between an 18-wheeler and a truck. During the accident, I lost my left leg. I chose Siniard Law because my granddad knew they had a great reputation. They were very knowledgeable. They were very sweet. We had a connection. They pretty much treated us like family. I would definitely recommend Siniard Law because they are caring and they will help you get what you deserve. If you've been injured, call Siniard Law.
Welcome back to the Siniard Law Show. If you'd like to sign up for Siniard Law's newsletter, which provides free monthly legal tips, scan the QR code and be sure to sign up at siniardlaw.com. Now let's get back to the attorneys and the topic of injuries. So Frank has emailed us. He says, I am an electrician. I hurt my shoulder almost 3 weeks ago. It's still bothering me. I told my supervisor, but he keeps brushing me off. What should I do about it?
Hire a lawyer. Harry, we get this question a lot. People are hesitant to reach out to a lawyer. I mean, what would you do if you were meeting with this guy?
Well, so certainly kind of what you alluded to just a second ago, people are nervous to contact us, right? And especially in a workers' compensation setting where his supervisor may also be one of his buddies or something like that. And they're not wanting to put them in a bad position. And that's not always the case. I mean, if we take the case, we have to notify people that we are representing them in a matter. But at the end of the day, we're not going to take steps that are detrimental to you, right? So if you say, I just want information, I need to know what my options are, we can certainly go that route about it. Your boss, your supervisor, whomever doesn't have to allude to it. For this question, though, and this viewer, what they're saying or what they're asking is, well, what are the options? You told your boss about it, but you haven't done anything. There's requirements under the Workers' Compensation Act that you notify your employer in writing, right? Just because you tell your supervisor may not be sufficient enough to keep your claim open, keep it active, and move forward receiving medical treatment. A lot of it is, try to get something in writing, whether it's an email, a letter, whatever it could be, documenting that you did report it. It's been 3 weeks since the incident and nothing's happened. I mean, in my experience, I'm sure Bart would agree, that's a long time for there to be no medical treatment and you haven't heard anything.
Yeah. I mean, I don't know what the reason is for it. He may just need to be a little bit more forceful or insistent.
Or maybe he knows that it's not in writing and he's hoping that it doesn't go any further.
That's possible.
Yeah. A lot of times like major employer, I won't say their names, but they have, manufacturing facilities in North Alabama. They'll send you to the on-site nurse, who patches you up and says, take Tylenol, because they're trying to get you back out there and don't want to open a full claim. Sometimes you just got to be an advocate for yourself and say, no, I know something's not right.
Well, can you lose your job?
Well,
yes and no, right?
Yeah.
You're not supposed to be able to, but Alabama's an at-will work state. So you can't be, from a legal perspective at least, you can't be fired for filing a workers' compensation claim, right? That doesn't mean it doesn't happen, because it's so rare to have that smoking gun type of evidence saying, hey, fire Joe because he made a workers' comp claim.
Yeah.
A lot of times what an employer will do is, we see a lot of things, but it's, oh, we didn't like your shirt, or we're cutting back, or the company didn't make as much. And there's always some valid excuse, if you will, as to why you got fired. Just because it looks like a duck and quacks like a duck with Alabama's workers' comp, doesn't mean it's a duck. And that's the issue people run into.
Yeah, you're not supposed to be fired for instituting a workers' compensation claim. If they do fire you after you have filed a workers' comp claim, you can try to bring a completely separate case for wrongful discharge, wrongful termination. But you have the burden of proof, like Harrison was talking about, to show that the sole cause they terminated you was because
better be squeaky clean.
you got your attendance has to be clean. You got to have great reviews. Wearing the appropriate attire to work. Like, I always tell workers' comp clients of mine, it's like, follow the company rules while we're going through this. Okay, follow the company rules. Don't give them any reason where they can say bye-bye. And you got to, because there's a lot of employers out there who are looking for a reason to fire people who are hurt on the job, sadly. And they got workers' comp insurance. They just are frustrated by it, that they're going to have somebody out that they probably can't replace because they know you're going to be coming back. So there's this temporary disruption in workflow. But I mean, it's true. You got to stay squeaky clean, like you said, while you're getting treatment.
All right, well, let's get to an email from Sarah. She says, my grandmother broke her hip and had surgery and went to a nursing home for rehab. But when she was there, she fell again. She went, I guess, back to the nursing home, fell again, trying to go to the bathroom. So is that nursing home where she was having rehab responsible?
Yeah, and that's it depends. And there's a backstory on this. Falls in healthcare facilities are one of the biggest preventable incidences that occur. A lot of people, almost everybody in a nursing home is considered a fall risk. And there's testing that they're required to do by federal regulations. You can be not a fall risk at all, or you can be through the roof. But depending on where you fall on that scale, a nursing home in particular is required to institute a fall risk care plan. And it's also called plan of care. It's the same thing, but there's federal regulations for nursing homes. And what they have to do is, if certain patients have certain issues, like being at risk for falls, they have to create a documented care plan that says, this patient's a fall risk, and here's the things we're gonna do to prevent somebody being hurt or killed from a fall. And that can include skid-resistant socks, making sure the call light's within reach, responding to the call light when it's buzzed, making sure the floor is free of clutter, making sure they're on a toileting schedule. And let me stop right there, because that's usually when the falls happen, is an elderly person has rang the call button because they need help going to the bathroom, and nobody's come. And it's been 10 minutes, it's been 20, it's been 30. And they say, I gotta go to the bathroom. So they try to go on their own, and they shouldn't. Like this lady had just had a hip surgery. She didn't need to try to be going to the bathroom on her own, I'm sure. But she did. And the question I have is, why did she? Why did she get up and go to the bathroom unassisted? Was she there trying to get help and couldn't? Or does she have some kind of mental health, dementia, cognitive issues, where she doesn't know she's at risk of falling? So I'd have to ask the potential clients some more questions and really dig into the medical records. And tell them about digging into the medical records when we're looking at a case.
Yeah, what comes to mind first, at least with this question, is, was it witnessed? Did anybody happen to witness the fall? Was anybody around? Or is it like Bart said, is she ringing the lanyard the entire time? Nobody's coming. She's got to use the restroom. And in doing so, she falls. A lot of times what we see is that, it's defended as nobody saw it. Nobody ever witnessed this fall. So how do we really know how it happened? And where that becomes an issue, and why somebody like this should probably reach out to an attorney and have us review the medical records, is because it's an important part of figuring out exactly what happened. Not everything might be documented in the records appropriately, which is another cause for concern. But at least those records and review of those records will let us know, what is their care plan? Is somebody supposed to be helping them? Is someone supposed to be checking them? Is the lanyard placed within reach next to the bed? Is that documented? So a lot of times the review of medical records for a nursing home is less so what it says. A lot of times it's what it doesn't say, or it's what didn't happen that sort of leads to us uncovering whether or not this nursing home was negligent. So if I were this person, I would first work on requesting those records on behalf of your mother, but second, get to an attorney who can review those and let you know what the options are. Because there's a lot of gray area within medical record review where it may say something, it may not say something, but you really need somebody who's familiar with looking at those and reviewing those to tell you what the options are.
Sometimes it's frustrating. Anytime somebody's bringing a claim, they have the burden of proof, and you can know and you can think that something wrong happened, but can you prove it? And so sometimes what they're called in the legal and medical profession is an unwitnessed fall. If we don't know why the fall happened and the patient can't explain it, so a lot of times people in nursing homes, hospital, have dementia or Alzheimer's or some medical condition that affects their memory. I mean, even they may not be able to tell you what happened. I see that a lot. And so falls can happen without negligence. Not every fall is preventable, and we would never claim that. But a lot of them are if you're instituting a fall risk care plan and putting in place all these different measures that can reduce the chance of it happening.
Let me throw something at you.
Okay.
What if your family had a video camera in the loved one's room?
They should.
Is that admissible?
Yes, absolutely.
It is, and we also see a lot of these nursing homes now are implementing policies that say, you can't have a camera in the room, and you sort of go, well, I want to be able to view, my loved one, but it's they're trying. Basically, if that's in their policy or the contract you sign, moving it in there, I'd run like hell.
Really
if I
go
could,
to a
because
different place.
there's no chance that your loved one is going to be taken care of there. If they're already disclaiming your right to be able to view your loved one, there's a reason for that, and it's probably because they've had multiple falls previously.
Yeah, I mean, we see that a lot.
Okay. Very good. Thank you. Thank you, Bart Siniard and Harrison Lane from Siniard Law, for all this great information on injuries. And we look forward to hearing from you, our viewers, with your questions about injuries or any legal topic you'd like for the attorneys to tackle. You can email us at questions@siniardlaw.com or call our voicemail line at 844-7000-LAW. Join us next Sunday night after the late news. Good night.
The preceding was a paid presentation by Siniard Law Injury Attorneys. Paid for by Siniard Law Injury Attorneys.